So many freelancers have had the experience where they couldn't receive service fee in addition to specifying the terms and conditions of the transaction. Hi, welcome again to my channel. I'm Atsuro Tsujino, a lawyer working in Japan. Today, I'd like to talk about what you should know when you work as a freelancer in Japan. The reason why I picked up this topic is because there was new legislation about protections for freelancers. Perhaps it's the same in other countries, but unlike workers, Japanese law doesn't give much protection to freelancers. There was no organization like a labor union to protect them, so they need to be smart and protect their own rights. As a lawyer, I often give advice to freelancers, and the most frequently asked question is, I have done the work, but they won't pay me. What should I do? In such cases, I always ask them like this. Do you have a contract with the company? A key point here is, you should make a contract before doing the work. If you don't have a written agreement in place, you may be told things like, we didn't ask you to do that job. You did it voluntarily. I didn't think your fee was that high. Half of that is appropriate. Your work is poor quality, so you need to redo it until we can be satisfied with it. We can't pay you because you haven't completed all the works we hired you for. Many disputes arise from lack of agreement. Conversely, if mutual obligations are clearly defined in the contract, the parties will try to fulfill their obligations at all costs, because if they do not, they will be in breach of contract and they will lose in court. However, some of your clients may find it troublesome to draw up a contract. In such cases, it is important not to be obsessed with formality. It is not always necessary to have complete contract, signed and sealed by both parties. If your client tries to avoid making a contract, you can write in an email the terms and conditions of the deal. If your client orders your service after reading such email, the terms and conditions written there will become binding. In fact, so many freelancers have had the experience where they couldn't receive service fee because they started a transaction without signing a contract. But I think the number of such cases will gradually decrease in the future. This is because Freelancer Protection Act was enacted on November 1st, 2024 this year. Freelancer Protection Act is a law introduced to enhance the protection of freelancers. This law made it a legal obligation for companies to clearly state in writing or by email the terms and conditions when they order work from freelancers. In other words, companies will no longer be able to order work from freelancers based solely on verbal instructions. According to this law, when a company orders service to a freelancer, they must propose in writing or by email the detail of the service, the amount of service fee, the date of payment, and other important conditions designated by this law. In addition to specifying the terms and conditions of the transaction, the law also states that service fee must be paid within 60 days. So if a company fails to pay service fee within 60 days for a job done by a freelancer, it will be a violation of this law. Furthermore, the law also describes prohibited things that a company must not do when they outsource services to freelancers for longer than 1 month. Specifically, the law prohibits refusing to accept the work done, reducing service fee, returning deliverables without good reason to get refund, forcing to do service for unfairly cheap fee, forcing to buy or use their own product or service, requesting an unfair economic advantage, unreasonably changing the detail of the ordered service, unreasonably forcing to redo the work. So if a company treats a freelancer unfavorably taking advantage of its strong position, it will be likely to fall into one of these prohibited acts.
The Freelancer Protection Act also includes regulations on termination and non-renewal. If a company terminates a contract with a freelancer that is valid for 6 months or more before the expiration date, or decides not to renew such contract, the company must give 30 days notice to the freelancer. In addition, if the freelancer requests the company to disclose the reason for termination between the date of notice and the date of termination, the company must disclose the reason.
Moreover, when outsourcing work for longer than 6 months, companies are obliged to make necessary considerations so that freelancers can balance their work with childcare or nursing care. For example, if a freelancer is unable to work for the scheduled hour due to sudden illness of their child, companies may need to consider whether or not they can adjust the deadline for the service. So, as you can see, Japanese government is now trying to expand legal protections for freelancers. I think this is in order to tackle with labor shortages in aging society by allowing a variety of work styles. Legal protections available to freelancers is becoming more similar to that available to employees. In this video, we have looked at the problems freelancers can face and protections they will be given under the new law. Freelancers need to be smart and protect their own rights. So it is always important to update your knowledge about what kind of protections or benefits that are available to you. And this is something that companies using freelancers also need to know to avoid breaking laws. Preparing or revising template of service contract will be the first step for many companies. The topic of freelancers is not small, so I couldn't cover all legal issues in one video. But in a later video, I'm planning to cover some other issues, such as companies who unfairly regard their employees as freelancers. This is a really serious problem, so it would be interesting to talk about it in my channel. Thank you for watching. See you in the next one. Bye.